Okay, why don't we start? More people are still rolling in. So I am delighted to be here with Lauren Cosulich. This is the second time that we've done a presentation, and we're really excited to do this. This is the finance and family presentation for private equity executives. And I want to thank those who signed up. I know that we have people, not only the private equity executives themselves who've signed up, but also we've got a lot of advisors on the line, and we're really delighted to have you here. There's a wealth of information, and we're happy to share with you. I should mention that if anybody has questions during the presentation, throw them into the question and answer spot. We'll answer them at the very end. Unless we see something that we think needs to be answered immediately, then we might interrupt each other. Otherwise, we'll answer it at the very end. We have a lot of material to cover. And if afterwards you've got questions that you think of later, or you want to talk to us about this, then at any point, give us a call. We'll be sending around an email after it's done. So you'll have our email addresses, our contact data, and we're glad to speak with you at any point. So again, it's finance and family for private equity executives and the advisors who advise them. Private equity executives, as you know, they typically have asset portfolios comprised of numerous diverse funds and investment assets. Some of those are illiquid, vested, unvested, inchoate, fluctuating in values based on market norms, based on politics. Some are on vesting schedules, and some of the holdings may be in startups that require the use of complex valuation methods and schedules. So some of these require some extra planning by your financial advisor and your legal advisor. You want to use a separate set of assessment tools. These are sophisticated valuation portfolios that require a specified understanding of market norms and valuation around venture capital. It's important to work with the right team of wealth advisors and lawyers who understand equity stages and challenges and calculations of return during the estate planning process and during the legacy process, philanthropy. You need to know these things. And so we've all come together to give this kind of information to each other. The benefits of estate planning and financial planning and tax planning for private equity executives are enormous. Hedge fund managers, venture capital partners, private equity partners are uniquely situated to reduce extraordinary gift taxes and estate taxes, generation skipping, transfer tax liability. So we want you to understand some of the planning techniques, not only just estate planning, which people's estate planners do all the time, but the family planning, the legacy planning, the next generation planning. That's the type of planning that will help you guard against a panoply of legal claims, such as divorce and dissipation of value and assets. Divorce in particular can upend long-held expectations of wealth accumulation and distribution. And so we'll be talking not only about the financial issues and next-gen succession, but also divorce, prenuptial planning, and what happens in the blended family when you have rivalries within different degrees of family kindred, and how to get through that. So without any further delay, I'm going to turn it right over with my first question to Lauren. So Lauren, tell me, how does building a structure and a plan for your important assets benefit the important people in your life?
Thanks, Lisa, and it's a pleasure to be here with you today. I'm so pleased we're talking about this because these topics really are so important. Really it's all about just tying everything together, right? There's wealth accumulation, there's sort of acquisition and accumulation and enjoyment, and with that requires elements of protection and planning. A really excellent financial advisor will centralize the information regarding these various components of one's life to ensure that everything is in fact working in concert to achieve whatever the identified objectives are. One question that we often ask of our clients here at Summit Trail Advisors, where I'm a partner and an advisor, is, what is this for, right? What do you want from this wealth? And that really ties very specifically to what values a family has. It will inform the set of objectives that we want to sort of have as our guideposts for the strategy. And so that strategy, as we talk about it, really does require very sophisticated tax strategy components, and also I think sort of education and implementation for trust and estate planning, particularly with respect to legacy and next generation, and sort of the generational wealth transfer that some of our clients are really seeking, and also the protection components like you talked about earlier with respect to you know, sort of divorce or other challenges that could present themselves. And like I said, you know, family is really so often at the center of these priorities and goals, but obviously family dynamics can vary widely. So what is meant by blended family planning? And at what point would you say that people should start thinking about that, you know, with respect to an upcoming blended family?
So that's a great question. You know, we all know that relationship is so precious, delicate, and our anticipation that relationship might last doesn't always happen. Divorce happens, death happens, disability happens, and it happens in all families. And so understanding some of the nuances of blended family planning is very important so that we can make sure that our intentions are met. We all understand intuitively who it is that we're supporting, who we feel an obligation to support, and who's going to be the recipient of our wealth when we're no longer around. But a lot of times we don't put that into place. And as we create blended family structures, suddenly there's the risk that long-held expectations that are internalized and family paradigms for the way that we consider who it is that we care for, who it is that we take care of, who are our dependents in our family, suddenly that can be upended without even realizing it. So for example, when we get married for a second time or a third time, our subsequent spouse has marital rights that are set out by the matrimonial laws in Massachusetts and in any state. And those matrimonial laws will confer benefits for a spouse that could actually upend your estate plan. It could actually change who gets what, your dispositive scheme. The same with inheritance law. When we marry, there's marital rights, matrimonial rights that are also impacted in the inheritance laws in Massachusetts and all states. If we don't do our estate planning, then, or if our will fails for any reason, then there are statutes in Massachusetts and all states that determine who gets what based upon degrees of kindred, based upon who is your spouse at the time you die, who are your children at the time you die, and whether your spouse is the parent of your children. And there's many different configurations to this. People start to think that step parents or step children have a certain legal right, but the fact of the matter is they don't. They are legal strangers, and so there is no inheritance right there. But what if you adopt your partner's children? Then yes, your spouse's children are your children, and suddenly there could potentially be inheritance rights, there could be custody rights, support obligations, different impacts that people are not always aware of. So in blended family planning, we need to be very careful to take a look at our probate assets, our non-probate assets, really identify what our intentions are, and make sure that we are going to the right advisors who can ask the right questions about the infrastructure of our families, because it impacts the way that our disposition of assets is going to fall later on in life. Lauren, have you seen situations where a person's separation agreement, for example, might impact their finances? I know I have, and tell me what you've seen, and feel free to ask me about that too.
Yeah, absolutely. I mean, in my work, we also have had to sort of be side by side with our clients through plenty of divorces, which is unfortunate in some cases and also very exciting, right? We're really pleased to be a part of sort of the next chapters. And so, you know, understanding the nuances of what the different agreements are is really important, and understanding what that translates to with respect to liquidity and income for their investments and their broader balance sheet is critical. But I would imagine you've seen some situations where there's been inconsistencies too between, let's say, like a separation agreement and a prenuptial agreement. Is that the case? And like, how do you avoid litigation, or what comes from those?
Exactly. So as a lawyer, I handle not only the divorce side, but also the fiduciary side, family planning, and and the estates, the trust and estate side. And so when I work with my clients, I ask them for the separation agreements from their prior marriages, as we're working on the prenuptial agreement, and as we're working on the estate plan, because there will always be a situation in a separation agreement where some assets, especially in the private equity space, in that industry, sometimes assets are inchoate or unvested. And so very often, as you're getting out of an old marriage, when the last marriage, you're asking your spouse in connection with that separation agreement to wait until an asset vests, or to wait until there's a return or a different stage in equity before or sale, a business sale, before any of that value is transferred to the ex. And when you're doing that, sometimes you're asking your spouse to wait a long time. In some of the divorces that I handle along these lines, I might front end alimony, knowing that we're going to be asking a spouse to wait for property division. And so you're front ending the alimony, making it a little more robust from the beginning so that you can back end the separation and the division of assets on the other side. And when you do that, people are waiting for that ultimate disposition and the ultimate pulling apart of the two spouses who are now exes, and really separating. But in that period, while people are divorced and the assets are not fully distributed, every now and then people are marrying, in between they're getting married again, and they have a prenuptial agreement, or they do some estate planning. And perhaps the asset that was to be transferred later is an asset that finds its way into a prenuptial agreement or an estate plan, and it's to go to the new spouse. And then you've got potentially litigation between your ex-spouse and your new spouse and your children from both spouses after you've passed away, or even while you're alive, because expectations are upended. And so it's very important to take a look at this. The other thing that's very important to take a look at when I'm doing family planning for a new marriage, I'm also asking for copies of corporate documents, business documents, beneficiary designations, fiduciary control. Who controls your foundation? I need to know this, and who controls the stock in your business? And this is one way that I can plan for succession with my clients without having inconsistencies, conflicts, and overlaps that are going to result potentially in litigation. The idea is to give you a smooth continuum from one relationship into the next without upending lots of expectations and unwinding your own intentions. So I plan for successors, plan for disability. That's part of the planning that's done. Family values have such a significant impact on the wealth protection and wealth transfer strategies. Of course they do. But Lauren, tell me, how should families think about instilling their values in the next generation?
Yeah, it's really interesting in our work, collectively here with ultra high net worth individuals and families, because, really many of the same, what we might sort of consider to be like blue collar values can be applicable here, but it's even harder because, when you have great wealth, when there are tremendous means and resources available, it can be more challenging to raise kids who are independent and respectful and resilient, and who are still going to be motivated to go out and, perform in their best manner and live fulfilling lives that contribute to the world, assuming that's what parents want from their children, right? That they're not just entitled, layabouts. And so, finding ways to live one's lifestyle in a manner that conveys those values. I mean, we say so often that our kids are watching us, and they're watching what we do more than they even listen to what we say, right? So so sometimes there's just behavioral norms that you establish, but sometimes there needs to be even more, right? There needs to be additional conversations or additional sort of programs set up with them. And that ties also then, like you were talking earlier about, generational wealth transfer, and when you make decisions about gifting, how you're gifting, et cetera. And, one thing that I like to remind my clients is that, you shouldn't necessarily parent by tax code, right? Just because something is doable or optimized from a tax efficiency standpoint or a tax saving standpoint doesn't necessarily mean it's the right thing for your family, right? It could be, and perhaps that's the priority. But really, we want to ensure that our clients are making decisions based on what matters to them within the boundaries of what's available, what the options are, and sort of what makes, good financial sense. I think another sort of piece to that is really, in a gradual manner, integrating older children into, and sort of young adults into conversations about family assets or wealth, and, let them participate in decisions, because in that manner, you can establish a sense of responsibility and a sense of sort of family legacy, again, sort of tying to the values that the family has. I imagine that also ties to, as when we're talking about young adults in particular, their own future matrimonial plans, right? So how do we start the process? How do you start the process? Or how would you recommend, that with my clients or other advisors, of sort of acculturating those young adult children to the need for a prenuptial agreement, and sort of how do we or how would we help the sort of first generation to protect their trusts and their assets from the children's future potential divorces?
Right. One of the things that we have as an advantage, it's a great question, and as an advantage, I think the young generation now realizes that things happen that you don't anticipate. Look at the whole COVID pandemic. We never thought that this would ever happen. And that's one way to have a conversation about things that we don't anticipate. We expected in March of 2020 that people would get right back to school and work within a few weeks, within a month. We were going to flatten the curve. Remember, flatten the curve.
Oh, yeah.
Years later.
2 years later.
And it's a whole new thing. And we've changed the way that we work irreparably. And as we're talking about prenuptial planning with our children, one way to have this conversation is to talk about the fact that things happen that we can't anticipate. And of course, we trust in the family, we trust each other's decision for a life partner, and we welcome that person into our lives, and we want to always expand family and expand love within our family, but we can't anticipate everything, and there's so much that we don't know that might happen and unravel in the future. So that prenuptial planning is a conversation that we should have early on with our children. Our children realize that we are living comfortably. They don't need to know the value of the wealth of the families that they're growing up in, but they realize already, they recognize that they're living comfortably and more comfortably than many other families. And that is another way to start the acculturation process, the family paradigm process, where you talk about, we have so much for which to be thankful, but we need to protect and make sure that this family wealth stays within the family in the event of any sorrows and difficulties. During the beginning days of the pandemic, families pulled together, and they had enough. Those families that had wealth had enough in order to protect each other and take care of each other. So use that. This is the generation gets it. The generation now is ready to do that prenuptial planning. And so in addition to prenuptial planning for the younger generation, I generally will ask my clients to show me the trusts that have been drafted and that might have been in place for years or decades before, to which the young adult is going to be a beneficiary. It may not even be our trust. It may be the prior generation's trust or multiple generations ago. But you want to take a look at the assets to which our children, the one who's getting married, to which they have a beneficial interest. What trust are they a beneficiary of? We want to look at those trusts and look at the wording. We want to find out to what extent does that child of ours and their incoming spouse have rights to demand withdrawal? To what extent must there be withdrawals of perhaps 5% or 5,000 or whatever it is? To what extent does our children have rights to demand principal versus income, and how much value is in there? We want to take a look at this. We also want to look at marital exclusion language, because there has been a cascade of cases that have been decided over the past 8 years that speak to property division. And we want to make sure that when we're doing our prenuptial planning on one side, that we're also taking a look at the trust interests to which these children, these adult children, will eventually have an interest, because those trusts are vulnerable in divorce. And we don't want the family trusts to be invaded or attacked in the event that our adult children's marriages don't work out, whether it doesn't work out a year later, a decade later, 4 decades later. If the family wealth is meant by this family to be kept within the family, then you want to have your prenuptial attorney look also at the estate planning instruments and the trusts to which the new spouse, the fiancé, is a beneficiary. And there may be reason to decant assets from one trust to another. There was a case in Massachusetts, the Ferry Powell case, where there was a decanting of assets to protect against divorce. And the decanting happened years after the trust was established, and the court permitted it. It was a decant, and then the trustees went to court and asked for the court to ratify, to bless it, make it kosher. And the court did so. It was an amazing case. And so we want to be thinking about this in the work that we're doing with our families. Yeah.
So that makes so much sense. And obviously, advanced planning is just so critical. There are always, it seems, headlines about very wealthy sort of middle-aged couples getting divorces. I mean, we had the news of Bill and Melinda Gates, last spring, and everyone's been watching Mackenzie Scott and Jeff Bezos. What is your sort of best or most impactful point of entry when someone senses that their own marriage might be on shaky ground?
I definitely want to make a most impactful entry. That is so important here. There is enough wealth and sophistication in the structure of the wealth that there needs to be a very impactful point of entry. So what I would do is I like it when a client comes to me when there is a little bit of shakiness in the marriage, even if it doesn't turn into divorce. Come to me anyway. I have a lot of clients who have been working with me for years. We're hoping they'll never, ever get divorced. But I'm doing the planning with them. We're looking at this. We're looking at their prior generations' estate plans to which they're a beneficiary. What will they be inheriting themselves, and making sure that we're making any changes we need to do. We're taking a look at foundations and fiduciary control. You remember, you mentioned Bill and Melinda Gates. So they looked at this together. They decided to handle it together, and they made a contingency plan. What if we can't? That's the kind of planning that I would like to do with my clients in advance, so that we can start the thinking about fiduciary control of foundations, fiduciary control of assets and trusts and business interests. I like to do some interceptive trust planning. Maybe we do some changes in the trust, maybe some interceptive business planning, and maybe change some business documents. Maybe we make some shares non-voting, or we change, we protect against fiduciary control from an outgoing spouse that may not be good for a family business, a closely held business, where you really want to keep an infrastructure and where there's already an allergy to in-laws. But believe me, ex-laws is even a worse allergic reaction. So I like to do that kind of interceptive planning, and I can be most impactful if I can do some of that in advance. There's also a few marriages that deserve to be held together. Every marriage deserves the shot at holding it together. You know, we don't marry lightly. We marry people who we think we can live with forever and love forever. And when a marriage is rocky, that's a perfectly normal thing. Not all relationships are swimming and easy every day. And sometimes you go through years of difficulty and then restore the marriage. And so in the work that I do, sometimes, you know, I do like to think about introducing some separate support complaints so the parties can separate, still be supported, and maybe come back together. I do some postnuptial planning. Sometimes in a marriage, you might have one spouse who has a mental health issue or a gambling issue, or perhaps has someone on the side, and you just want to make sure that assets are held safely and divided in advance, or somehow there's some kind of restraint and control so that the parties can stay together, remain married, work on the issues together without a risk of the marital estate being dissipated. And so these are ways to hold marriages together despite the very significant forces that just naturally press on all of our marriages all the time.
Yeah. So there clearly are sort of various steps you could take pre-divorce to protect those family assets, you know, in those situations where we might sort of smell smoke but not yet see flames. What are the processes to actually sort of start the divorce, and in particular to try to keep it non-acrimonious, or try to get it done quickly and without too much pain or destabilization?
Right. So there's different process issues that come up in divorce. When I handle a divorce, I like to keep it as elegant as possible. I like to go to opposing counsel and explain that we're going to reduce our acrimony. We are going to handle this in a mature and creative way. We're going to build legacy planning concepts into the work that we're doing. Keep in mind, we're talking about wealthy midlife divorce. This is a unique divorce. This is not your cookie cutter divorce. This is a sophisticated divorce where there needs to be sophisticated planning between the wealth manager and the divorce lawyer and the estate planner, because we need to figure out a way to push assets and legacy to the next generation as part of the divorce, right, rather than have this be just a complete out and out war of the roses, or, you know, we don't want the acrimony. We want to do this in a smart and mature way. So I generally will ask that we file for divorce after we have agreement. Sometimes that's not possible. Sometimes we think that assets may disappear if we don't file right away. And so sometimes there's a reason to file right away. But if possible, in a wealthy midlife divorce, I like to see if I can negotiate the terms with opposing counsel, just sitting down with the parties on separate telephone lines, not necessarily in the same room, or in the same room if it works. And in a four-way situation, see if we can at least get rid of the low-lying fruit, figure out what we want in terms of asset division, in terms of alimony, in terms of children, if there are any minors. Very often in the wealthy midlife divorce, it's midlife, the kids are older, they're teenagers, they're in their 20s, they may even be in their 30s or 40s, but or older, but you know, at least having some negotiation right up front, some clinical support for the two spouses. That is my preferred method because it's far more elegant and sophisticated. If you hit impasse, or if the parties simply can't negotiate, then mediation is one way to handle this, where you bring a third party in. And this is why I'd rather do it myself without bringing a third party in. I'd rather do it with opposing counsel. And if opposing counsel has sophistication, we'll have a good process. We'll have a creative, mature process. But if it doesn't work or you hit impasse, bringing a mediator in or a conciliator is one way to get there. I've also handled cases as private adjudicator, and I have brought divorces to private adjudicators. When we're dealing with these sophisticated asset structures, we don't want to drag this through the courts. We don't want a judge to have to adjudicate this, and we don't want the general public to be made aware in the context of argument in court of the level of assets. And so I would rather that we keep it out of the courthouse. My clients generally want to keep it out of the courthouse as well. It's not a very dignified place to be, and going through divorce is not a very comfortable thing for anyone. So going to a private adjudicator is one way that we can keep it out of the courts and have somebody else essentially serve as arbitrator and make some decisions. And there are certain lawyers in any state, but here in Massachusetts, where some of us do that private adjudication, and it makes the process a lot better.
Yeah, that makes so much sense. And I could not agree more with your perspective about, you know, for these wealthy midlife divorces, trying to approach the situation with sophistication and with a sort of preference for elegance, as you've said, and negotiation, right? And really not look for, be looking for settlement and not looking for acrimony is so much more effective. You know, we often are involved and brought in fairly early on as well. And to your point, you know, impact is key, right? You know, there are some very specific considerations for private equity executives who are getting divorced. You know, in particular, there's sort of this very big question about what does the carried interest count as, right? Is it an asset that's going to be divided, or is it income? And in different situations, you know, it will depend, right? And in some cases, it could be advantageous to do it one way versus another. And, you know, that's a really important question that, you know, the attorneys and the advisors like myself are working through with our clients to understand what the sort of knock-on effects for that would be. And, you know, tied to that, of course, is questions about liquidity and sort of what's on the balance sheet in this sort of next chapter in the post-divorce, post-settlement era. And, you know, I think, again, in situations with our private equity executives, there's a lot of illiquidity on their balance sheet, right? And there often is a very high level of income, and that income sustains certain spending, and that income is often supported real estate purchases, but there may not be a lot of liquidity outside of the, you know, LP capital that's in those particular, you know, funds over and over. So there can be a lot to sort of sift through. And one thing that we work on with our clients is really trying to understand what that sort of marital balance sheet looks like, and see, again, you know, as early as possible, if there is some sort of division that can be made that is, you know, reasonable and optimal for both sides, right? That will allow for an agreement to be established and a settlement, you know, to be reached. And, you know, and really that's about ensuring that there's consideration given to all of these issues of, you know, how does the carry count? What does that translate to from an alimony standpoint? What are the assets that perhaps, you know, the non-earning or the no longer, you know, the non-private equity spouse to live on in the sort of same manner that they've been living on. And so those are all of the sort of factors that we think about when we're working on a private equity divorce situation specifically with our clients as part of their broader sort of balance sheet.
That's so helpful. How do you approach the management of a family's liquid assets?
Yeah, it's really, I think, important to recognize, again, particularly for private equity executives, that there's often a really big difference between their liquid assets and their total net worth. Excuse me. And so, you know, on paper, they may sort of see certain figures or sort of view themselves and recognize their family as having a certain level of wealth. And, you know, and that isn't always sort of that doesn't translate necessarily to sort of what's liquid and what's available to be managed from an investment standpoint, what's available to be spent, or allocated from a kind of expense or purchasing standpoint. And I think in particular for younger private equity principals and partners, the last decade plus, we've really only had a very healthy environment for private equity. And so it seems like everything only ever goes up, and there's always going to be great, gains to be made. And I think we always want to remember that there are market cycles. There's reasons why, you invest in private equity in different vintage years to have exposure, because those cycles will vary. And so, having that sort of long view is always really important. And in our work, we're thinking a lot about, what's diversified versus our clients' concentrated positions in private equity, right? What are, both from a liquidity standpoint and from a actual sort of investment or asset class exposure or risk level. The liquidity piece is also really key, because the capital calls for those LP commitments that they've made can be very idiosyncratic. Also, there are tax liabilities, and sometimes those dollar amounts or the due dates for those amounts don't necessarily line up with the tax distributions that are made from the funds. And so again, having a good advisor is helping, will give you the opportunity to sort of help track that and understand, what's a reasonable amount to be sort of holding aside in various situations as distributions are coming out, so that there's not a crunch at any point for covering those liabilities. Beyond that, when we think at Summit Trail Advisors, when we think about managing, a family's investment assets or their sort of investment portfolio, we use a framework that's really about kind of identifying the purpose of funds. And so we sort of think about a set of the allocation, a subset of the allocation that's really for sort of preservation and ability to sustain one's lifestyle. And those will be a little bit less risky investments. And we will think about other more sort of growth oriented and risky investments as really, sort of designed for creating legacy. And that can be for generational wealth transfer. That can be the sort of aspirational part, the money you want to grow to be more philanthropic in the future, whatever it is. And then we also sort of include an overlay for purchasing power, maintaining purchasing power, and sort of thinking about inflation considerations. With all of that, of course, there's, considerations about tax efficiency and, what's the sort of net return. And so, there's a lot of consideration brought into all of that. But, one of the most important things that we find over and over is that the question of how the assets are held is so key, right? And whether it's inside the estate or outside the estate, it matters so much, particularly when you're thinking about and talking about what you want for the family and, sort of what the family's legacy can be and how you can potentially ensure that the next generation is benefiting from everything that you've accumulated during your career.
What are some approaches you've used with your clients for generational wealth transfer? And how should families think about the timing of that?
Yeah, so the timing is always an interesting one. And, I'll say sort of irrespective of private equity executives, sort of specifically, the concept of gifting to the next generation really comes down to this question of, of what and when. And the analogy I like to use is you could gift an apple, from an apple tree. You could gift, let's say, perpetual access to your apple tree. You may have apples every fall when they're ripe. Or you could gift like a seedling or a sapling that may not be producing apples right now, but that will grow and have apples aplenty, for years and decades to come for your child or for those beneficiaries. So, ultimately it's really a question of what does the family want, right? What's important to them. But the sort of basic idea is that the earlier you can get assets outside your estate, and the more that those assets have an opportunity to appreciate outside the estate, the the better off you will be with respect to minimizing estate tax liabilities and maximizing the amount that's transferred to the beneficiaries. The 2022 exemption amounts, as you well know, obviously are 12.06 million at this point. That's the highest they've ever been. And that's on a per person basis. So for a couple, we're talking about, really $24 million of assets that can be, held within the estate, and everything above that is going to be subject to estate taxes unless there are strategic transfers being made. The approach that we see most commonly for private equity executives, and sort of the simplest, would be vertical slice gifting, where an equal amount of the interest in the limited partner capital and in the GP carried interest is gifted into an irrevocable trust for the beneficiary. And when you do it in this manner where those percentages are proportionate, then you don't sort of fall into a challenge where there's a deemed gift that you didn't intend, with respect to the appreciation and the size of the GP interest. It can be challenging when the LP interest is, or the LP capital is a large amount, but that's kind of the simplest and most basic for private equity partners.
Very interesting. Tell me a little bit about, in terms of the timing and risk of family discord. Have you had any situations where you've been doing some estate planning and gifting and you're thinking about family discord and the timing of it that way?
Yeah, it's always tricky. And again, families are, each one's unique, and there's sort of situations that you have to navigate. But, we like to ensure that there are conversations happening with our clients and their beneficiaries as, a start. And we also like to be thoughtful about, those questions of how are the estate plans structured in the first place, right? And that sort of, are you talking about real estate? Are you talking about financial assets? Are there other sort of questions that come into play? But I imagine, the most important thing here is to sort of engage the right attorneys and to sort of ensure that there are sort of protections established from the get-go. I mean, I imagine that you've seen a bunch of these. So how do you keep those family disputes in sort of within the scope of legal documents and outside of the public eye?
So that's a great question. And we all know that Britney Spears had a very public conservatorship and a big family dispute between her and her father, including some wealth management firms. And it was quite a fiasco in 2021. I see this a lot in my practice, not only conservatorships of people who are very high profile, like Britney Spears, but even those, whether or not high profile, there are certain inflection points that come up. One of those might be a late in life romance, where we might have a person who's aging and experiencing some incapacity, or somebody young like Britney Spears, who has different issues that come up that create an incapacity to rationally process different financial issues and to make and exercise good financial judgment and personal judgments. It happens at any age, but it especially happens as people are getting later in life. Sometimes they might bring in a new life partner later in life while they themselves are starting to experience a diminishment of capacity, or perhaps they don't have somebody in their life, but the children, the adult children, might have some rivalries for the assets of the patriarch of the family or the matriarch of the family, and it creates internal family discord. Sometimes we'll see cases where there's allegations of undue influence, where perhaps a romantic interest is influencing or is alleged to be exploiting financially somebody whose mental capacity is starting to diminish a little bit. We all know that we don't go from being 100% competent to incompetent in a day, but there's a gradualness to incapacity that happens through the years. We're living longer, and there is a slowing down. There's many different types of dementias that occur, from Alzheimer's to many, many others. And what happens is we do see claims of undue influence and financial exploitation. Very often I'll be asked to represent somebody who is either high profile or not, but in a situation where somebody is high profile, I'm asked often to serve as conservator or guardian. And it is my job to protect their reputation and to not let the public see that there may be a mental status weakening or a diminishment of capacity. And so I will be in the shoes of that high profile person to make decisions. My job is to give them dignity, privacy, autonomy, but protection of reputation, and to prevent a situation where we might have an embarrassment, especially by somebody who is high profile or who has high wealth and lots of commitments to people both in the business community, but also politically and globally. So my job is to handle certain interceptions so that I can be sure to provide dignity and, to the extent possible, choice, but certainly to prevent embarrassment and protect reputation. I do that through guardianship and conservatorship, but also through just the social act of leveraging influencers that I identify as being in the lives of my clients. I'm not only a lawyer, but before then I was a social worker. So I bring a systems approach and I navigate systems for people in my capacity as lawyer.
Yeah, that I love that part of your history where you really do have the sort of background and the skills to sort of help your clients navigate that. From a legal standpoint, what tools exist to prevent those internal controversies from turning litigious, or alternatively, how do you restabilize? How do you restore order in situations?
So there's planning that can be done in advance. And then there's restabilization that may happen when there's not time to plan or when the best laid plans don't come to fruition. But one way to plan in advance is when you're meeting with your estate planner. I know we also have advisors watching today's webinar. When your clients are meeting with you, think in advance about putting some exclusionary language in an estate plan that might say, what I'm leaving for you or what I'm not leaving is not for lack of love, but it's because I've provided in this way or that. Or perhaps you have something in your estate plan that excludes somebody in favor of someone else. You want to explain that in generous and kind words. You want to put it into the estate plan, because when your family is reading these estate planning documents, they need to hear your voice in this and understand your reasoning so that there's no post-death discord that can cause potentially a will contest or a trust contest, litigation within the family after you're not around. The other thing that I advise clients to do is to have communications with their family, perhaps at the Thanksgiving table or when people are all together, or at any appropriate time. You want to sit and talk about what your plans are and what your intentions are, so that your adult children can hear this, the whole family can hear it, it's acknowledged, it's witnessed, it's discussed, questions can be asked. It's an honest, compassionate gift. That's one way to do it. And then in terms of healthcare, certainly if you want to have a declaration in advance, like a MOLST where you're describing or a living will where you're describing what kind of treatments you do want and don't want, in addition to a healthcare proxy, and then explain that to your family too. That can be very compassionate. I see that we're getting towards the end. So I want to move right over to philanthropy. So, and I know that you've always said to me, Lauren, that in our industries together, there are 3 places that assets can go. You've reminded me many times. Let us know a little bit about that, and maybe you can speak to philanthropy, and then we should answer some questions and conclude.
Great. Yeah, absolutely. I mean, that's exactly right. We joke in perhaps a grim way in our industry that, you know, the assets can go to your heirs, to taxes, or to philanthropy. And those are really the only three buckets. You know, for a family that's philanthropic, there are a lot of questions to be considered. And, you know, the sort of first question is like, what do you want to have happen during the wealth generator's lifetime? And, you know, to what extent do you want the philanthropy to be something that they're, you know, where they're creating a legacy versus leaving a legacy? You know, there are naturally a lot of considerations to be made between, you know, in the decision about setting up a family foundation versus using a donor advised fund. And sometimes we see clients who kind of pair those together. But really, you know, there's a lot of pros and cons to each with respect to privacy, flexibility, but, you know, ultimately identifying the priorities for the family and sort of thinking about what types of gifts the family might want to make will be important in informing that decision. You know, and then we talk with our clients a lot about, you know, planned giving and the opportunity to think about philanthropy as part of their estate planning, you know, maybe in addition to what they're doing in their lifetimes. And, you know, again, there's different entities that you can create and all sorts of sophisticated things you can do there. But really, you know, what we look to encourage our clients is to think about those long-term objectives. And again, it all comes back to sort of what are the family's values. This is a topic that's a really excellent way to engage various family members and be thoughtful about, you know, what you're discussing with the next generation. And, you know, I know that's an important topic, you know, for so many reasons. We actually have a question about prenups. I think it'd be great for you to address. You know, the question here is, when you have great wealth in the family, is it possible to stipulate in a trust or in some sort of legal document that a child would only have access to those assets if they do, in fact, you know, create a prenup prior to their future marriage? Or is that something just that happens sort of in conversation and sort of advised, but not legally mandated?
It's a wonderful question, and it's a nuanced answer that I can give. I have dealt with this before. I think the way to do it is to put language into a trust that says the trustee is prohibited from making distributions to a child who's married unless there's a prenup, and then speaking with the child about this and identifying this as being a family protective mechanism, that opening the door for the trustee to make distributions during your child's marriage without a prenup means that those distributions to the child that were made without a prenup will potentially open up the trust. It creates a great vulnerability. There is what we call in the divorce world, the fabric of the marriage, the way that you weave the fabric of the marriage together. And if the marital couple has lived on assets or has increased their lifestyle because of assets that have been distributed from a trust, that trust is potentially very vulnerable to attack if the marriage doesn't last. So we do put some language right into trusts that speaks to that very issue. Is it enforceable only as against the trustee? It's not going to force your child to establish an estate plan or a prenuptial agreement, but having conversations about this and acculturating the children early on and saying, you know, we need to do our trust planning, and our trust planning needs to protect our family and multiple generational lines going forward. And so we have put in a provision in there that will protect the trust by disallowing any distributions unless you have a prenup. We're doing this, you know, for protection of the entire family. That's one way to have this conversation and to have it be done. So great question. It can be done through trust, but there's got to be communication within the family about this.
Mm-hmm.
Yeah.
Yeah, I think I was going to say, I mean, I think that sums up everything that you and I have just spoken about, right? I mean, it's so much about communication and, you know, sort of recognizing what's important and then speaking about it as a family.